Our home is the most highly protected place under the Constitution, under the Fourth Amendment. Yet you'll see video after video after video of police officers around the country not really caring at all. Take a look at this video from Leavenworth, Kansas, where you have a call for an illegally parked truck allegedly outside this man's house that somehow turns into 5 cops entering his home without a warrant with their pistols drawn and scaring the hell out of his daughter. It just goes to show the importance of a case that's actually at the U.S. Supreme Court right now on the so-called community caretaking exception, which does not exist, but which law enforcement, mayors, the government basically is trying to get the U.S. Supreme Court to establish as a third exception to the warrant requirement. Take a look at this video.
Robert Ennis wants to know how a call for an illegally parked trailer turned into this.
4 or 5 police officers with guns drawn.
Firearms in hand and Leavenworth police entering a house when the owners were not there. Ennis says his 12-year-old daughter was the only one home outside with neighbors when police arrived.
It's traumatizing that my little girl's home. I'm not there. There's nothing I can do, and she's scared. She called me crying.
Police say the officers' intentions were good. They say after knocking on the door, it opened. Ring doorbell footage tells a different story. You can hear a doorknob twist and the officer knock.
Open door.
Earlier that morning, the family made sure that door was shut.
Is that door shut all the way?
After failing to get in touch with the owners, police say the officers made a judgment call and went inside to see if someone was hurt.
So thanks to the Ring doorbell video camera and audio, law enforcement got caught going into this house, firearms drawn, searching the house. And their response is that, well, they were just doing it because they were worried about somebody inside. Well, as we all know, there is a requirement to have a warrant before law enforcement can enter and search somebody's home. And the U.S. Supreme Court has held that a warrantless entry into the home is constitutional in just 2 narrow settings, and that's one, of voluntary consent of the occupant, or exigent circumstances, which is like an emergency. You can look at Stiegel versus United States, Supreme Court, 1981. There's no other justification that works. Even plain view doctrine does not allow law enforcement to search if they see something that's illegal in plain view in someone's home. They came up with this thing called community caretaking that they've tried to extend in state courts in at least 3 different circuits to create a third exception to the general warrant requirement. And that reminds me of what's happening in this case. They're trying to bring up that they were not looking for evidence of a crime, but they were just coming in because they were looking after people in the community. The door was open and they thought maybe somebody was hurt inside. The case that's currently at the U.S. Supreme Court is called, Caniglia versus Strom. And it's really the simple issue over whether there is a so-called community caretaking exception that is applicable to the home. It's already been applied by the Supreme Court in at least 3 other cases to automobiles, and that's really what it's pertained to, was sort of inventory searches of automobiles. But, as cops did with the Terry line of cases, they're trying to get more and more and more power and create less and less privacy and less freedom for citizens in their cars, as pedestrians, and most importantly, in the home. I've been critical of the ACLU. It seems like all they've been really worried about are, getting biological men in the bathrooms of biological women in our country's public schools. But they actually filed an amicus brief, which is a friend of the court brief, with the Supreme Court in this Caniglia case, and it's actually really, really good. And so I pulled this amicus and some others. In fact, the Gun Owners of America also filed a good amicus brief in this case, but there's a lot of good Fourth Amendment stuff in here. And this in particular, they wrote this just as far as the basis for why the court should reject this community caretaking exception to the Fourth Amendment requirement. In a famous case concerning the writs, colonial attorney James Otis argued that a man's house is his castle. You've heard that before. And while he's quiet, he's as well guarded as a prince in his castle. The writ, if it should be declared legal, would totally annihilate this privilege. So John Adams, who was in the audience that day when this was said, later observed that this lawyer Otis's ferocious defense of the home struck a chord with the budding revolutionaries, proclaiming that American independence was then and there born. That was mentioned in Frank versus Maryland, a 1959 Supreme Court case. Then after independence, Adams penned a provision of the Massachusetts Constitution that specifically protected the home and, quote, served as a model for the Fourth Amendment. Now, this special protection for private dwellings provided by the Fourth Amendment does not vanish simply because the government claims to be motivated by something other than law enforcement purposes. To the contrary, as originally understood, the Fourth Amendment prevents, quote, all invasions on the part of government and its employees of the sanctity of a man's home and the privacies of his life. So, in other words, it's irrelevant whether the original justification for the search was to detect criminal conduct. The Fourth Amendment protects all of us. Even the most law-abiding citizen has a very tangible interest in limiting the circumstances under which the sanctity of his home may be broken by official authority. That's from Camera versus Munn, Connecticut, 1967. So the reason for that is because there are a lot of government agencies, there are a lot of defendants in lawsuits, police officers, who will claim that, well, we weren't looking for evidence of criminal conduct. This was, something that was administrative or things of that nature. And this has also come up in the context of code enforcement, administrative searches. But that's for another video. So as the ACLU makes clear here, and they're absolutely right, we are all protected by the Fourth Amendment, not just somebody who committed a crime or who is suspected of committing a crime. But I'll also point out that in this video we watched, they were originally there to investigate whether or not the truck and trailer were parked illegally, which is ridiculous that they're somehow going from that to coming in the house with the pistols drawn. And you know what? It's also ridiculous to make the argument that, well, that's how we search. We always pull our pistols out to search. But again, that's for another video. So when people say, well, you have nothing to hide, that's just saying, well, nobody should have Fourth Amendment rights. If you have nothing to hide, let the police search. If you have nothing to hide, talk to the police. That's just saying completely get rid of your Bill of Rights, because just trust the police if you have nothing to hide. So take a look at this Caniglia versus Strom case that's currently pending before the Supreme Court. Because right now, regardless of what the Fifth Circuit says and the First Circuit says, which is where this case came out of, and I think also the Eighth Circuit is the other circuit that has expanded this community caretaking doctrine to allegedly allow police to go into a house without a warrant. It's not so. So pay attention to the case that's before the Supreme Court and understand that there is really no good basis for this as of yet. And I actually even had a case here in the Fourth Circuit where they allowed this, where there was a warrantless search inside a house. The community caretaking doctrine was brought up. And while the Fourth Circuit didn't specifically address it, that was the argument argument underlying the grant of qualified immunity in that case. And unfortunately, the Supreme Court of the United States denied cert on it. So we'll see. If I would predict that if the Supreme Court does not come out and affirmatively say that there's no community caretaking exception, that the Fourth Circuit will run with it and act as if there is. The term community caretaking first appeared as an offhand remark in the Supreme Court's discussion of automobile search procedures in the Cady case from 1973. And again, this is going from the ACLU's amicus, which is very good. So this off-duty police officer was in a car accident while driving under the influence. disabling his vehicle, and substantially injuring himself. So, like Ronald Reagan said, the 9 scariest words in the English language are, I'm from the government and I'm here to help. So even though this guy was part of the government came to help him. And you'll see that this community caretaking stuff applies a lot in firearms cases. They're used to very much like red flag laws and used in conjunction with red flag laws. They're from the government and they're here to help you to confiscate your firearms because they're worried about their community caretaking. They're going to, community caretake you right into prison. So while searching for the weapon, the officers inadvertently discovered evidence implicating this guy's involvement in a murder. This evidence was introduced and used against him at trial, and he was convicted. So it went up on appeal, and the court drew exclusively on its prior automobile inventory jurisprudence to uphold the legality of the search. And that's basically when we arrest you while you're driving your car, because now we're responsible for all of the items of personal possession in your car, or personal property in your car. We just need to do a great job of doing what we do and make sure we inventory all those items. Of course, for your own good, to help you, for everybody's safety. And we really know it's to search for evidence, but they've been allowed to do this. So it was through the automobile inventory exception that this community caretaking stuff started. So relying on this precedent, the Supreme Court, in the Cady case, found that police had this general caretaking responsibility to inventory the contents of Mr. Dombrowski's vehicle, and that was the basis of it. So in the Cady case, however, the court explicitly and repeatedly distinguished automobiles as inherently different from homes, because remember, homes are more and the most highly protected of your whatever us peasants get in this country under the Fourth Amendment. So vehicles are technically effects under the Fourth Amendment. There's a difference between houses and cars. Now, the Cady case established this narrow exception to the Fourth Amendment applicable only when a vehicle is taken under police custody or control. So that's based on, number one, the reduced expectation of privacy in a car. Secondly, the propriety of non-criminal inventory automobiles, though that's a fiction. I mean, that they're obviously searching for evidence of a crime. And 3, the adherence to standardized police procedures as a check on police discretion. Yeah, right. So this court revisited the community caretaking exception only 2 other times. And again, this is referring to the U.S. Supreme Court in the context of standardized vehicle searches. Again, so South Dakota versus Opperman in 1976. The Supreme Court upheld the search of an impounded car. So Opperman reiterated Cady's narrow holding that it did not recognize a caretaking exception separate and apart from inventory searches of cars. Instead, the Opperman court made explicit that the caretaking exception of Cady hinged on the fact that the officers were exerting control over property and have caretaking responsibilities over those properties. Yeah, right. But still, if it just applies to inventories of cars, it does not have anything to do with a warrantless search of your home. So the final and third U.S. Supreme Court case on the community caretaking exception was the Colorado versus Bertine case, 1987. And that was where the court said it never permitted the expansion of Cady beyond this original exception. And this was another police search of this guy's vehicle after lawfully taking control of it, which just means he probably got arrested in his car. So the justification for this so-called caretaking search was to inventory the vehicles that were now in the possession of the police. So again, had nothing to do with the home. So that's the U.S. Supreme Court case law. And now you had some of the lower federal courts that ran with this, unfortunately, and that's why it's now at the Supreme Court. So among federal courts, Fifth Circuit was the first to use Cady to justify warrantless entry into a home. That was United States versus York, 1990. Okay, that was, let's see. Eighth Circuit was next, United States versus Quezada, 2006. So that was where the police went to the homeowner's residence to serve a protective order. And look, just like the video I showed you today, allegedly upon knocking, the door became ajar. Officers called out, no one responded, but because the lights and the television were on, the officer entered the home. Defendant was found sleeping with a shotgun, was arrested for being a felon in possession of a firearm. The only other one was the First Circuit, in this case, the Caniglia case that's now at the Supreme Court, where the First Circuit had completed what it called an odyssey, taking the caretaking doctrine of Katie far beyond its narrow origins that it was supposed to be limited to according to the Supreme Court. And then, as the ACLU points out here, there's a number of state courts that also had ran with this and created their own so-called community caretaking exceptions. And it points out what some of those are. Let's see, down here in a footnote. Who do we have? Maryland, of course, Maryland, Wisconsin, let's see, Michigan, Maine, I guess that is, and Virginia. So not quite surprising. So that is really the history of the so-called community caretaking doctrine. And it really doesn't have a whole lot of history. You just have 3 U.S. Supreme Court cases that had to do with the inventory of personal property of somebody they arrest who was in a car. That's pretty much it. And you've had 3 lower circuits that have tried to extend this. And then you have some state courts who've tried to extend it. But remember, states cannot, their legislatures, their counties, their cities, they cannot violate the federal Constitution. So they can't do it either. And so if this U.S. Supreme Court makes it clear that there is no community caretaking exception to the warrant requirement, then that should, you would think, put an end to it. But we shall see. So thanks for watching.